Hi, this is Nancy with Prager Law LLC. We are a full service intellectual property and corporate practice with clients in the entertainment and technology industries, as well as other businesses and individuals too. And in fact, the issue that I want to talk about today relates to a matter we recently settled for an individual client, an influencer. The influencer had been referred to us after they discovered a video they had posted online was being used by a brand to promote the brand's goods and services without permission from the influencer. Among the issues the client reached out to us about was copyright infringement. Our client was aware that they had a copyright in the video they had posted. But I asked a question during intake that surprised them, and it made me realize that this is an issue that far too many people are unaware of, and it needs to become a best practice for influencers and content creators alike. First, let's talk about the copyright of it all. What is copyright? Copyright refers to the bundle of exclusive rights that is granted by law to the creators of works of original authorship that are transfixed into some kind of medium. It can be a book, it can be a piece of digital art, it can actually be software and a screenplay. Copyright attaches automatically once the work is transfixed into this medium, and the exclusive rights are incredibly valuable to the owner of the copyright. The exclusive rights include the right to make a copy, the right to make derivative works, which are works that are based on a pre-existing IP of pre-existing copyright. Think a movie based on a book or a television series based on a podcast. Both the book and the podcast were copyright protected, and the other projects derive from that original copyright. But for most works that are protected by copyright, they also have the exclusive right to publicly perform the work. And in the case of our client, the brand using the video without permission was infringing both the performance right, but also the copyright, the copy and the performance. So they were infringing the copyright. So my client was aware of that. And then I asked a question. I said, do you have a registration on this video at the Library of Congress? And they said, no, we don't need one. Copyright attaches automatically. And I said, oh, that's true. It does attach automatically. But in order for you to enforce your rights, you have to have a registration at the Library of Congress with in the Copyright Office at the Library of Congress. And that is mandatory in order to maintain a copyright infringement action against an infringer in federal court. You have to attach the registration certificate to the complaint, and it has to be filed when you file the lawsuit. And they were like, wait, what? And I said, I know. It's not well known that you have to have the certificate. And it's only in the United States, as far as I'm aware, that this is a requirement. And it's very frustrating. But it's possible. If you find out somebody's infringing, you can go and register the copyright and wait to get the certificate or pay an expedited fee to get it done quickly because you need to file the lawsuit. But registration alone isn't necessarily enough. You have to register in a timely manner to get all the benefits of copyright law for litigation purposes in the United States. What is timely and what are those benefits? First, what are the benefits? Didn't think I was going there, right? The benefits are statutory damages, which allows an infringed party to get up to $150,000 per infringement, as well as attorney fees and cost. Without a timely registration, you can only get actual damages. And in copyright cases, actual damages may be pretty paltry. So when the Copyright Act was enacted back in 1976, they included these statutory damages to discourage copyright infringement. So what is timely? Because that's key. Timely applications are filed within 3 months of publication of the work that's being protected or prior to discovering the act of infringement. So in our client's case, they discovered the act of infringement before they called us. So they hadn't yet registered the work. And that would have been detrimental to them getting anything other than actual damages. They wouldn't qualify for statutory, except for the fact, because they're an influencer and this video was so fresh, was so out of the oven, that it had only been posted for a few weeks when all this happened. So we were within the 3-month period of time, and our client was able to file the application for registration and qualify for those statutory damages. What I walked away from this, we settled the matter with the brand, and our client is continuing to do their work as an influencer, and it's very exciting. But what I took away from this was that too few people are aware that you have to have the registration in order to file a copyright infringement action. And if that registration wasn't filed in a timely manner, you don't get all the benefits of statutory damages. Therefore, I think it's really incumbent on influencers and content creators alike to get in the habit of registering their works with the Copyright Office in a timely fashion. We are going to provide links below to the Copyright Office so that they have tutorials on how to register the works, how to file the applications. My piece of advice to people is to download the PDF of the form that you're going to be filing online. Do not file a paper form unless you have to, because it's much more expensive. And so that you can fill in all the information that's going to be required so you have it ready when you go online to the portal to do the applications. Additionally, if you are a single creator of a single work, look for the special application that is available to applicants who qualify, that's less expensive than the regular application. And finally, if you are trying to register works before they've been published, please make sure to read what the Copyright Office provides about unpublished works and groups and registering groups of unpublished work. As always, this is provided as an educational service of Prager Law, but if we can be of assistance in substantive matters for you, either to protect your intellectual property or to enforce your rights, do not hesitate to reach out to us at info@pragerlaw.us and click to subscribe to our social media channels to stay up to date on the issues that we are following and talking about. Thank you so much for your time.